Well, a North Idaho man accused of shooting and killing a fellow chiropractor suffered a brain injury when he was arrested last week, and that's according to his lawyer. Daniel Moore appeared before a judge in Bonners Ferry this morning, and he was arrested last week and charged with shooting and killing a man back in March. Moore is a chiropractor from Bonners Ferry, and the man he's accused of shooting was a chiropractor in town as well. Authorities haven't said why they believe Moore killed the man, but court documents say the victim was shot in his back through a window. The man died in his office, and this morning, Moore's lawyer expressed concerns that he was questioned by police after that brain injury. A judge then granted a request for Moore to be transported to a local hospital to receive an evaluation.
Wow. Wow. Let's take a look.
To be and the court can see that this vehicle identification was heavily relied on by the state to arrest Mr. Koberger, as well as to obtain a lot of other search warrants. This is information that is very necessary for us to prepare our case. I don't think Mr. Thompson and Ms. Jennings are withholding anything. I think they don't have it, but I think we need a court order with the deadlines so that we can get that. As the court is aware, the state has a duty to provide discovery to the defense.
All right.
Transported to a local.
The court's read the probable cause affidavit that led to Mr. Koberger's arrest, and the court can see that this vehicle identification was heavily relied on by the state to arrest Mr. Koberger, as well as to obtain a lot of other search warrants. This is information that is very necessary for us to prepare our case. I don't think Mr. Thompson and Ms. Jennings are withholding anything. I think they don't have it, but I think we need a court order with the deadlines so that we can get that.
Wow. Do you guys remember that? Do you guys remember that at all? Do you guys remember that at all? So Aunt Taylor is asking for that video that was used in all of these search warrants, heavily relied upon in the probable cause. Where are we at today? We still don't have the video. She still does not have this video. That's wild. Like, absolutely wild. Look at this. Misconduct by defendant officers of the Bonners Ferry Police Department and the Idaho State Police. These officers deliberately denied Dr. Moore his constitutionally secured rights by ignoring his multiple requests for the assistance of counsel, threatening first-degree murder charges if he didn't confess, and using other abusive, overreaching, and coercive techniques to extract a false confession. In their case in chief, in any subsequent criminal proceedings. So, as well as a potential motive for the shooting. Oh my gosh, to avoid potential interference. You guys remember having making all those phone calls, right? Well, I heard back. I got a phone call back. You guys ready for a bombshell? I'm going to tell you a bombshell. I got a phone call back. I got a phone call from Avista. Brian Scrumshire, his legal counsel, they called me back. They have no idea that this case even exists. Excuse me? Wait, come again? What did you just say, Lana? Avista Gas Company has no idea that the Brian Drake / Dr. Moore case exists. Excuse me? Wait, what did you just say? Nobody has spoken to Avista or Brian Scrimshire since May 19th, 2020. Girl, I'm going to repeat this one last time and then I'm going to have to block you. You could come here to my house and try to find this alleged smoke detector. It is undetectable. You don't understand. There is no smoke detector in my house that's even plugged in. None. Nothing is plugged in my house right now. So where is this coming from? No idea. If you think I'm lying, come on down. Search it for yourself. Again, how is that possible if the Avista gas employee was interviewed by the police? Exactly. Because he was interviewed about a gas leak, not about a homicide. He was never interviewed about Brian Drake's homicide. He was interviewed about a isolated gas leak that the police then assimilated and associated. So again, spoke with I was contacted. I didn't go blowing people up. I was contacted based on, you guys heard the voicemail that I left for Brian Scrimshire. Brian Scrimshire, the Aveda, everybody needs that good hair product, Avista Gas Company. Avista Gas Company legal never contacted. Brian Scrimshire never contacted, as in, what the fuck are you talking about, Lana? This is this wild voicemail I got. Legal contacted me to say, we have no idea what you're talking about. I was blown away. Blown away. Just like I'm blown away. Look at how good that blonde looks right there. On the top. You guys look at that platinum just popping. You guys understand this, right? I can't make this up. Avista is located in Spokane, Washington. Spokane. All right. Why is Avista contacting me wanting to know when this so-called trial date was? What information I had on this, because they have no idea about what I am speaking of. I said, well, aren't you guys listed as like an expert witness? You guys were opined and mentioned in a 23-page August 31st, 2022 opinion from the Supreme Court. Do you guys know that? No. It's on Justa. Like a publicly, like, just type in Dan Moore and Dr. Drake case, look it up. I mean, I was over here just like couldn't even fight beside myself because I'm like, what the fuck is going on? Anyways, the reason that this matters is because I'm over here. I want to do like some phone calls and ask some questions. Have you guys come up, give me what you guys would put down as your questions on a questionnaire as far as, can Brian Kohlberger get a fair trial in this area? Well, I don't think Brian Kohlberger has a chance. Your smoke detector has a capacitor built into it. It holds a charge even when the battery is removed. No, there are no smoke detectors up. They're all out. They've all been unplugged, hardwired. Everything is out. Don't block you. Well, I will, just because like if you're going to comment on it, you get blocked. That's how it works. So, and I've never even seen her name before. Deuces. I don't need the help. I'm well aware of how to change a smoke detector battery. Literally, there is no smoke detector in my house that has batteries in it or is hardwired. I've made this known multiple times. So moderators, anybody that mentions a smoke detector, automatically delete from chat. Not just delete the comment. I want them banned from chat. Thank you. Because it's distracting me way more than the beep. You know what I mean? So go watch something else. I don't give a fuck. I got way more facts than probably all of these channels combined. That's how I feel. So, Lana, you cracked me up. Yeah. Put some earbuds in so that your dogs don't hear it barking or beeping so that they bark, or don't listen to me. I'm sorry, but that's how I feel. And by the way, I love Aveda too. I think that's why it was just a Freudian slip. So you like that stuff, Kara? Yeah, there you go. Oh, I can't pin it when I'm on this way. I have to be like inside the chat from like my phone, and that's just not necessary. Anyways. So I think it's very important to talk about a lot of things when it comes to the police department seems to want to use somebody as an expert, and the expert doesn't even know that there's even a case. He thought he was talking to somebody about an isolated gas leak. So can you imagine when you want to talk to somebody about, now let's talk about Brian Kohlberger's case. Hey, we want to talk to you about something. Have you ever seen something like this before? You know, I can only imagine like the AVAC guys, like, hey, have you ever seen a door open for like 12 hours? Like, how low would the temperature fall? There you go. That's what we need to talk about right now. Woo! We're winning over here. Anyways, welcome to the transparency. Welcome, welcome, welcome. Want to take a look at something real quick. Made a bunch of videos back in the day. And again, this is why Tolson, we want those training records, because Tolson trained everybody, you know. Yes, he did. Remove that. I want to add this. Share this screen. And I want to go back to, we need to talk about, let's see, videos. Video file. I want to talk about these Venmos. 3:33 p.m. I mean a.m. They become relevant.
Yes. It's my job to determine the manner and mechanism of death.
take a look. Just handing them. If they were such badasses, they should have been like, that shit is not abandoned alcohol. They're just handing them over like a bunch of pussies, but that's my take. Here you go. Pour this out. Pour this out. Nobody abandoned the liquor, the alcohol. You know what's crazy is he's like, I have no idea who lives here. We want to talk about lying. We want to talk about people that lie to the police. Everybody that I've ever seen on camera has lied to the police in all the body cams I've gotten my hands on. Straight up lie to the police. They have no problem lying to the police. So now let's talk about it. The Venmos. Venmo. Venmo. Venmos. Let's talk about some Venmos. Let's see. Again, they were the drunk turkey had their baby. The drunk turkey had their baby. Had it collectively together, but yeah, so the drunk turkey had their baby. So congratulations, there is a drunk turkey baby out there. So glad I never used Venmo. Yeah, throw up those thumbs, throw up those high fives and hugs. Again, welcome. Okay, right there. Hold on. Kendra Schumacher paid Maddie Mogan pizza on 10/28/2021, which would have been the year they all lived together. 10/29, Maddie Mogan paid Connor. Maddie Mogan paid Haley breakup party. That would have been 11/3/2021. Let's see what else we got here. We got, like I said, pizza, 10/28. Bethany Funk, there it is. Bethany Funk paid Maddie Mogan on 10/22/2001, and she just put these flowers. You see that? These flowers. Okay, now let's see. This was a paper towels. Haley. Maddie Mogan paid paper towels. Now, let me ask you a question. Why would Haley pay Kendra paper towels? Maddie paid Haley paper towels. Okay. If the one person, Kendra, paid for the paper towels, why wouldn't Maddie pay Kendra the paper towels? These are when I find like weird things, when I was going through this. If you were the one that bought paper towels, I pay you. Why would I pay Haley only for then Haley to pay Kendra? Right? I would just pay my portion of, like, if, you go to Costco, it's $60. We got all these paper towels. And then you divide it by 6 girls. And so it's $10 per girl for paper towels. I pay the person, So that must have been January 25th of 2022. So this is during the time frame of the DoorDash. They went all the way back to January. So take a look at this. Dylan Mortensen paid Haley for clothes. Okay. So Dylan was always hanging out at that house. Dylan knew these people. So Haley lived at that house, by the way. And I would love to know what room Haley took over or Haley was in. But Wi-Fi, there we go. That's how I figured out where Xana lived before she moved in. So on May 16th of 2022, Xana paid for Wi-Fi when she was still living with Josie. Okay. So I was paying attention to these move-in dates. All right. Xana, right above that, Xana paid Hunter Johnson. And there was nothing as far as what it was for May 17th. Now remember, this is all public. So anybody could have viewed this back then. Xana paid Corbin. Good soup. All right, so then I went, here we go. Ethan's. November 12th, paid Jack. November 12th, thanks. Now, Ethan only on there had 31 friends. Okay. Right? 31. Add friend. There's 31 friends. I mean, I'm just saying. I believe that is 31 people that he shared this Venmo with. Like, that knew about it. Let's see. Now, all those hearts, they came after the murders, by the way. There was not 26 and 21 hearts like when that happened. This was after the murders. So Ethan paid Kaylee on November 12th. Yeah. Ethan paid Kaylee. Thank you. And then before that, again, the ride. Okay. Thanks to Jack. So actually the order is going to be the reverse way. So the most recent is paying Jack. So before that, okay. So see how it says November 12th? That had to be right before midnight, which would go into November 13th. But Ethan paid Kaylee the thank you. Then she paid the yeah. So the thank you was first, then the yeah. Ethan on November 11th paid Xana. So just so you guys know the order, it's not, you have to read down up. All right. Okay. So Dylan paid Maddie on October 12th. Now this is the same day. I really want to look at these days. October 12th is right around when Bethany got pulled over in Pullman. It was between October 12th and October 14th. All right. October wine plus candle wax thing. October 3rd, gas. Haley charged Maddie. As you can see, like there's nobody harding this stuff. We got this early on. Ashley charged Maddie for Sonic on October 1st. Where's the Sonic around there? You know? Maddie paid Kaylee for CLAS. Class without an S. And what do you guys think that is? Okay, right there. The lights. You guys saw the lights that were dangling? Right there, the lights that went outside September 26th. Maddie charged Xana for the lights. So they didn't have lights dangling in their back, you know, so I want to look back at those. Remember how dark it was back there? Look back at those body cams in September. But they went out and bought lights to light up that back porch and patio. So right here, Kaylee charged Maddie for the September Wi-Fi. Okay. So Kaylee, I'm curious to know if the Wi-Fi was in Kaylee's name. November 12th, Maddie paid Kaylee for coffee. But before that, utilities. Now, this is where I said something was weird, in my opinion. And you're going to see here, all right? So Ethan, see how his says 31? Maddie says 144 friends. Okay, Ethan only had 31 on that. And now these utilities on November 11th, this is interesting to me because Maddie and Xana were like trying to get Kaylee to pay utilities. Watch, you'll see. Look at. See, Maddie paid Xana sweatpants return minus utilities. See that? So minus the sweatpants return minus utilities. So I went and looked at Kaylee's stuff. Ooh, right there. Hold on. November 8th, you see utilities? November 8th, Maddie, that's to Dylan, utilities on November 8th. Kaylee paid Maddie on November 2nd, T. Kaylee paid Matt Casa for the house payment. That's what I would think, October 26th. I don't know. Xana paid Maddie Casa, I see, 26th. That's telling me that everything was in, you know, Maddie's name because Maddie was the original person of that house. Once everybody else left, it became like Maddie's house. You get what I'm saying? And yes, it is for utilities. Okay. It is for utilities. So I'm just showing you, it's not for anything. This is utilities. October 21st, tub. I mean, I don't know what to say about that. But everything's being run through Maddie. You guys see that? It's Maddie's house. That's why. Sorry, I meant to request. Maddie paid Dylan. Huh? Look at, that's where we saw that she was going to Luke Combs, and that was not until the spring. I want to go back just a little bit right to there. After the tub. Now remember, anybody could see this. This is all public. And here, right there, Maddie Mogan charged Kaylee. Sorry, I meant to request. Don't know. I mean, Maddie paid Xana salsa. Probably for going to that Mexican restaurant, Patty's. Maddie paid Kaylee pumpkin. TP. Luke. Right there. Everybody's making a big deal about this costume, about on what is it? For Halloween. Xana paid Maddie costume. See October 18th. Maddie charged Kaylee utilities plus house cleaning stuff. So anybody that's saying that like she was moving out, she paid for the house October 26th. That would have been for November's rent. Okay. So Kaylee's paying for the rent in November. So to say that Kaylee's moving out, she paid all of November's rent from what I can see, or at least that she was asking for her to be paid. Dylan paid Maddie utilities and cleaning. Maddie charged Kaylee utilities and house cleaning stuff. And what's interesting is that there's 2 hearts for that. I'm curious on who those 2 hearts were. Why are people hearting that? Like, that's super strange to me. It's like, hey, make sure that you pay your stuff. Because in fact, if she wasn't living there, but you said that you were going to live there, like, we're still charging you, you know? Because we're not paying, like, people that think like everybody was on like this separate bill. It was not that way. That's not true. Okay. Ethan, thanks. Okay, here we go. Ethan paid Kyle. Everything was like October 8th. The last time he paid him, I think I went to the other person. Domino's, November 11th. Ethan paid Xana Domino's pizza. So let me ask you guys a question. Remember how the dad said that they were having pizza? Okay. Then that, like, maybe he's mistaken the day before. All right. So, did they get pizza? Well, right here, the Domino's, that would have been the day before, like Friday night. So are they mistaken that Friday for Saturday? But right here it says like Ethan paid Xana for Domino's. So that makes sense to me that like staying in and ordering a pizza, here you go. It's right fucking here. So just like, wow, blow our minds away. Not really, just fucking read, you know? It doesn't say pizza though. It doesn't say pizza. Pizza is also code for something else. Well, it doesn't say that though. It says Domino's. It specifically says Domino's. Okay. So I think it's important that we just don't assume. Like, but here, look at the date. November 11th. Domino's. Woohoo! Well, somebody would have had to pay Domino's on some type of app. There's a call-in. There's a request for it. So we're going to see, oh, wait, guess what, guys? I believe that Domino's and that pizza, let's go ahead and mark that down then and being on Friday. Okay? And now that's interesting to me because Friday was the big night that they had that big party. Remember? Was the big formal. Well, here, Ethan paid Xana. So just because he went maybe to a formal for a couple hours earlier doesn't mean that he didn't come home and hang out with his girlfriend. All right? So, again, I'm not too concerned with how you spell it because we got people in Riley's case that don't even know what precinct means. Okay. So I'm not too concerned. With that spelling, not concerned at all. Again, so Friday night was the event. There was multiple events, actually. Now, on November 12th, the thank you. But right there, Ethan paid Xana for pizza, in my personal opinion, Domino's. That's exactly what it was. And there it is. So that now tells me that no, Ethan and Xana were not watching a movie that night and eating pizza. That's the night before. Okay. I think it's just right there, which actually would play into a lot more of, remember when they were trying to ask for, law enforcement was like, why or what? We want to go back to Ethan and Xana and we want more information on that because they figured out that it was the wrong motherfucking day that the dad was talking about. All right. So let's see here. Thank you. No, I'm going with what the parents said and that they had called in a pizza and they were eating pizza and stuff like that. I believe that's the other day. That's Friday night. And that would be something to me that they would have done after they got home. Now, this is when I went to Dylan stuff. And this is how I figured out that Dylan paid Simpson. And that's how I realized like she took over Simpson's part. Okay. Dylan Morrison paid Alice Simpson. That's the mother of Ruby Simpson. August 25th. Okay. And how I realized that she didn't move into no bottom floor like they all said was because of this. Look at what she does. The house, she says house payment, August 5th. Direct deposit, August 25th. Then she bought furniture off of the girl. All right. All of that is all of that stuff that's in that bedroom up on the second floor. And she took over the room in August. That's how I knew that none of the downstairs rooms was hers. Let's see. I wanted to look into, what was the other one? Dylan Morrison paid, September 2nd, rest of furniture. Now, September 2nd. So Dylan, I found out, was a coffee drinker because Xana charged Dylan Mortensen for coffee. But I realized that Dylan did not pay Kaylee coffee like everybody else did the day of the murders. Okay? So I think that y'all should keep that in your back pockets. So 100% Dylan Mortensen is a coffee drinker according to these, right? And you can say, well, coffee means something else. Well, let's just act like it doesn't. And it means coffee, you know? So September 2nd, you guys remember that when that would have been? That would have been the day after I gave you guys all the body cams. All right. So Xana charged Dylan Mortensen for coffee. Dylan Mortensen paid Ruby Simpson's mom for the rest of the furniture. Ethan paid Jack Katovich at 11:40 p.m. Thanks. At 11:40 p.m. Thanks. Public. 11:40. That screenshot was grabbed so early on that you're still able to see that it was 11:40. versus just having like the date of November 12th. Right there. Fake fight. Kaylee paid Maddie T on November 2nd, but October 30th, fake fight Ashley Valdez. I want to know what that means, and I'd be calling her to the stand. Kaylee paid Bianca, fake fight LMAO. And then Kaylee paid Bailey Hollow Weekend, okay? I don't see Kaylee in any of the Halloween pictures. Do you guys have Kaylee in any of the Halloween pictures? Let me know. Oh, look at a Vista. Then Kaylee charged Xana on November 3rd with this. Then Xana charged Kaylee a Vista. Then look at this. Maddie charged Kaylee these utilities because she did not pay, I believe, Xana the Avista. And that's why everybody was hearting this comment to say, Maddie, can you get the money out of Kaylee? Like, why isn't she paying us? Because something fucking happened, y'all. Think about this. You have Maddie's one, Kaylee's one person, two. Then you have Bethany, Xana, Dylan, Ethan. 6 people basically living in that house, minus the fact that Ethan doesn't technically live there. But you take Ethan out of the equation. You have Maddie, you have Kaylee, you have Bethany, you have Dylan, and you have Xana. And the person that the post is about is Kaylee. Kaylee didn't heart it, but the other 4 people did. And that's where your 4 hearts are coming from. Your 4 hearts are coming from everybody except for Kaylee Gonzalez. Okay? Xana tried to charge Kaylee for the Avista. Kaylee didn't pay her. Then Maddie, utilities. Let's see if you can get it out of her. Something happened from Halloween weekend, in my personal opinion, to then, look at that, November 11th is that Friday. November 12th is the Saturday. Look at 4 fucking hearts. Xana charged Kaylee on November 11th, power October. So you didn't, like, you need to pay for the power in October. November 3rd, asking her for a Vista. That's gas. Something happened with the members of this house between October, which would be October 31st, and something happened. Now, maybe it was Kaylee saying, I'm moving out. Okay, well, you're going to pay for your spot until you move out. I mean, you're going to pay your portion because it wasn't how you think it was. It was not divided up that Kaylee had to pay a certain portion. No. Kaylee paid Maddie. Everybody paid Maddie. And Maddie cut a check or did Zelle or whatever. And I wanted to show that Bethany Funk hardly, rarely ever did anything to do with Venmo. Now here, look at this. Xana paid Kaylee Hertz. Xana paid Maddie a star. Ethan paid Xana coffee on August 19th. So August 18th, 18th, 19th. Ethan paid Xana the 19th. Bar stool supplies. That's when they bought the bar stools that y'all see in the doors. Okay, paid Maddie for those stools, for those bar stools. That was in August. Right around, they're going to buy, in September, the lights. So they're starting to buy things because they don't, for their house, like they're like, hey, we're going to buy things for the house. Like that's what they were doing. Kaylee, Xana, thanks for watching Murphy. So is it unheard of that Xana would be watching Murphy? They're at the house and back before everybody else. So IDK how much I owe you, Ethan, to Xana on August 15th. Kaylee to Xana, thanks for watching Murphy. Xana paid Mia Darwood. Look at Britta and Patio Lights, August 17th. Again, Maddie paid for this, and she was charging Xana, like, this is, you owe for this. And then Xana paid Maddie for the bar stools for the kitchen. She accepted that charge. Again, this was all public. All right. So let's take another look here at one other thing with some of these Venmos. Google 2023.
And there's a person of interest. Nothing feels worse than having nobody and just nothing but doubt. And 7 weeks of honestly, I feel a little bit lucky knowing that we have somebody and there's a person of interest. Nothing feels worse than having nobody and just nothing but doubt. And 7 weeks of that, or close to 7 weeks of that, was a tremendous amount of pressure on us. And, your children.
This morning, Ryan Koberger faces 4 counts of first-degree murder.
All right, so I think this is going to be really important. Where was the white Elantra for those unaccounted 9 minutes between 2:44 a.m. and 2:53 a.m. according to the probable cause? The reason that we know this is because when you take Linda Lane into consideration and you're writing down the timestamps and you're doing these loops, between 2:44 and 2:53 a.m., where's this vehicle? Like, if it's Brian Koberger, where did it go? Where was it?
Honestly, I feel a little bit lucky knowing that we have somebody and there's a person of interest. Nothing feels worse than having nobody and just nothing but doubt. And 7 weeks of that, or close to 7 weeks of that, was a tremendous amount of pressure on us. And, you know, you children.
This morning, Brian Koberger faces 4 counts of first-degree murder.
Not a second throughout the day that
Saddle up. You ain't gonna believe this shit. Saddle up. Ain't gonna believe it.
you could imagine, it's just like a nightmare that you just never ever wake up from. There's not a second throughout the day that I don't think about Kaylee and what happened to her. It's sickening.
No, Steve, it took.
All right, guys, breaking news. Not going to make you wait any longer. Again, welcome to the transparency. Make yourself known by hitting the thumbs up or thumbs down once you decide whether or not you like the episode. This is going to be a quick one because it was very, very similar. White Elantra. They have I believe that is a Ring camera on the door as well. This was 8 months ago on Google, 2023. Suspect vehicle 1. Again, breaking news. In my opinion, this is belonging to Emma Bailey's one-time boyfriend, one-time pimp, one-time still time big drug pusher in the Moscow, Pullman, Washington area. A 2000, and you see it right here. This is Demetrius's brother's vehicle. Dark tint. 8 months ago. Again, it has the 5. It has the rims here. Again, tinted windows. It is the Elantra. And then 10 months ago, when I did a different angle and I was able to find it, you're able to see that there's another vehicle there. It is parked alongside. This is Demetrius Robinson's family member's vehicle. It is the same vehicle that they were looking for the night of homicides. Again, Emma Bailey, Demetrius Robinson arrested for the drugs that allegedly were that had fentanyl in it that killed Caden Young. Here is your vehicle that looks identical to what they were looking for, but is also very similar to what they would say Brian Kohlberger's vehicle. Again, we have found another white Elantra, and this is parked in the driveway of Demetrius Robinson's brother's house. Again, this is Emma Bailey's boyfriend's brother, and this is in Tacoma, which is where they were when Caden Young had OD'd. Okay. Again, I cannot make this any more known, but get this out there that this is the same vehicle that police were looking for, allegedly, the night that the 4 students were slain. So again, I'm very interested in the car that's parked next to it as well. This is a breaking and developing story. This is 8 months ago, parked in the driveway where the family member lives that is a family member of D. People know him as D. Demetrius Robinson. He is a well-known. All right, we're going to talk about a little bit here is as we flash back to certain things. I'm going to share with you guys something that's current. In the District Court of the 2nd Judicial District of the State of Idaho and for the County of Latah County, this is our declaration in response to defendant's motion to rescind order for failure to provide due process. Comes now the undersigned prosecuting attorney. Again, right here, this is March 29th. This was uploaded just today. Motion to rescind order for failure to provide due process filed on March 26th. On March 8th, so this is the state. Here it is. Let me make it big for you guys. Look at this. This is huge. Comes now the undersigned prosecuting attorney for Latah County, Idaho, and as an officer of the court declares and represents the following in response to defendant's motion to rescind order for failure to provide due process filed on March 26th, 2024. On March 8th, our office received information from a Latah County resident who received an unsolicited telephone survey regarding the Kohlberger case. Now, this is their... Here we go. He said, she said. Here we go. On March 8th, again, 2024, officers received information from a Latah County resident who received an unsolicited telephone survey regarding the Kohlberger case. Our office promptly forwarded that information to the Moscow Police Department for follow-up investigation to interview the person who received the call. Oh, hell no. Here we go. Ascertain the nature of the call and determine who was responsible for the call. Good thing mine was a joke yesterday. Several days later, our office received additional information that another Latah County resident was contacted by a telephone survey company. Our office forwarded that information to the Moscow Police Department to be included in its follow-up. You guys, if you're not getting Delphi vibes here, I don't know. I don't know what's happening here. So this would mean, okay, this would mean that if we looked at the reports, that someone from Latah, they must have just, did somebody call as a report out there? Hey, I got a phone call and they asked me a bunch of questions and I just want to report this to the police. Is that out there? Just curious. Our office has forwarded that information to the Moscow Police Department to include it in its follow-up investigation. On March 12th and March 19th, Moscow Police Department Corporal Brett Payne. Oh my God, his first name. I haven't seen it in 2 years. Okay. March 19th and the 12th, Corporal Brett Payne provided our office with the results of the investigation into this matter, which consisted of supplemental reports. Write these down. That means they're up to 260, 262 as of March 19th. What that means is that in this case, there would be supplemental 1 to 262 so far up to this case. Attached to the state's March 22nd, 2004 motion for order prohibiting contact with prospective jurors absent leave of court. So during the time between the initial information being received by our office, March 8th, and receipt of Corporal Payne's supplemental report, March 12th and 19th, our office became aware of 2 other individuals who received similar unsolicited telephone survey calls. One of those individuals recorded the call and provided a copy of that recording to our office, which was then transcribed by our office and attached to the state's March 22nd, 2024 motion for order prohibiting contact with prospective jurors absent leave of court as Exhibit B. The other individual provided a 1-page summary, written summary, which was attached. Oh, shit. Oh, for fuck's sake. Oh my God. Holy shit. I need a minute, man. The other individual provided a 1-page summary, which was attached to the state's motion as Exhibit C. It was suspected that the unsolicited telephone survey calls were being made at the request of or on behalf of the defense. On March 19th, 2024, Senior Deputy Prosecutor Ashley Jennings reached out to Ann Taylor and inquired whether she was aware of the phone surveys being conducted with Latah County residents. Ms. Taylor affirmed that she was aware and offered to meet with our office to discuss the afternoon of Thursday, March 21st, 2024, when she was going to be in Moscow. On March 21st, 2024, the undersigned met with Ms. Taylor, defense investigator Rich Batani, and Senior Deputy Prosecutor Jennings. During that meeting, Ms. Jennings and I were told that the survey calls were being made on behalf of the defense. We expressed concerns to Ms. Taylor regarding the nature of the calls and the fact that the calls were affirmatively sharing purportedly factual statements as reflected in the state's motion for order prohibiting contact with prospective jurors absent leave of court and its attachments. We expressed concerns to Ms. Taylor regarding the nature of the calls and the fact that the calls were affirmatively sharing purportedly factual statements. God forbid we actually have factual statements. We explained our concerns regarding contacting potential jurors and planting purported facts in the minds of those potential jurors who may not have heard those purported facts previously. Oh my God. Oh my God. What the fuck? Y'all. This is not. Is this April Fool's Day? Because I think y'all are punking me. Who is planting facts? You guys, is this a joke? Planting purported facts in the minds of those potential jurors who may not have heard those purported facts previously. This is particularly disconcerting because some of the facts referred to in the phone survey are not true and consequently would create a false impression or understanding with those. Later, this is their way of trying to separate themselves from the misinformation that they were not the leaks. This is fucking sick, dude. Oh my God. This is what they're trying to do with this. We told Ms. Taylor that our office felt this information needed to be brought to the court's attention. We proposed sending a letter to the court and attaching copies of the information received with copies to the defense. Ms. Taylor expressed concern regarding this procedure, indicating that she would want to respond to the information prior to the court ruling on the matter. We then discussed an alternative method by filing a motion with the court with the same attachments. Ms. Taylor again expressed concern with our office providing the court with anything before an actual hearing. We explained that a motion with supporting documentation is standard practice and that is the route we would be taking. Yeah, not ex parte. Following our meeting with Ms. Taylor, we consulted with our attorney staff and decided to proceed with filing a motion with attachments. That motion was prepared and filed shortly before 2:30 p.m. on the following day, Friday, March 22nd, 2024. The state submits this declaration in order to clarify for the record what has occurred in relation to the unsolicited phone calls being placed to Latah County residents and to correct certain representations contained in the defendant's March 26, 2024 motion to rescind order for failure to provide due process. Oh my God. So basically, Bill Thompson admits in part, denies in part. Bill Thompson admits that, and this is why I covered this yesterday, and I'm so glad that I did. The questions that were asked, they were close-ended, okay, for a reason, which is, I'm going to state this, and then you say yes or no. And they would be factually incorrect things, but these would have been coming from the 269 articles that were written. You think that they're going to do a question and answer session and not be able to back up why they're asking that question? Because then I think that that's crazy. And if Ann Taylor went ahead and did that, holy shit, like that's nuts, right? So here they try to get in front of this ball by disassociating themselves with what was said in the media. But you're basically affirming that what was said in the media is false. You guys get that, right? That's what this is about. Wowsville. Wow. Thank you, Bill. Thank you, Bill. Now, all right, let's take a look here at motion to unseal state's motion for order prohibiting contact, objection to defendant's motion to rescind, reply and support. Okay, here we go. Oh God, now the state wants to dude, they're trying to play checkers and chess. Okay. Now Bill all of a sudden wants to unseal the motion that he filed under seal. Okay. I kind of have to agree with you there, Miss Annie Potts. This is gonna get fucking wild. I told you guys, if you guys are following the Richard Allen case in Delphi and y'all think it's nuts, welcome to Latah County. Latah County, in my opinion, is Carroll County. So let's saddle up and take a look. And I kind of have to agree with that there, Miss Critical Thinking Cap. The person who notified the state of the survey and recorded the call to give to the state and police is proof the potential jury in Latah is biased. Shit. You guys, I feel like I am headed for a bruising. I feel like my name is about to be dropped in one of these segments saying, oh my God, Lana called one of the Latah County residents and said, hey, listen to this recording call. And they're not going to clip it all. They're only going to clip part of it. Okay, that's coming next. So just saddle on up. Let's take a look. Let's take a look here. Wow, this is getting wild. Let's zoom in. In case we're blind. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully requests that the court enter an order unsealing the state's motion for order prohibiting contact with prospective jurors absent leave of court. Filed herein on March 22nd, 2024, but keeping the attachment sealed. Fuck that. No. Put those motherfuckers out there to protect the identity of certain county residents and to avoid violating the court's non-dissemination order. No, fuck all that. We need to know who these people's relatives are so that they're not part of the jury pool. So we want to release, hey, we're going to release all of this stuff, but we are going to protect the people that sent us the information. What? That they literally proved Anne's point for the reason to change venue. I don't even have words right now. Why file it under seal? You know? In support of this motion, the state respectfully represents to the court as follows. The state asked that its original motion for order protecting contact with prospective jurors absent leave of court be filed under seal pursuant to the Idaho Court Administrative Rule 32 for the reason that the attachments to the motion identify certain Latah County residents who had received unsolicited telephone surveys calls regarding this case, and the state felt it was appropriate to protect the identity of those individuals. This is lies, y'all. This is lies. They always file under seal all of their exhibits, but we still get the motion. You know what I'm saying? And that's how they could have done it. The state was also concerned telephone survey contact contained information that could violate the court's non-dissemination order, including information that is factually false. Thank you. I cannot wait to see. I know. I want to hear the play that call. I want to hear the questions. Play that call. Play it, baby. Play it. Play the call. Subsequent to the state filing its motion under seal, an interim order was issued by the court properly prohibiting the parties from contacting prospective jurors, at least until the state's motion for order prohibiting contact with prospective jurors after leave of court was heard and decided. Following the issuance of that order, which did not contain any information that would violate the non-dissemination order, nor any factual information that was untrue, the defense filed a motion to rescind order for failure to provide due process. That motion contains representations that are either inaccurate or misleading as to events leading up to the state's March 22nd, 2024 motion for order prohibiting contact with prospective jurors absent leave of court. Unfortunately, the defendant's March 26th motion was not filed under seal. So anyone reading the defense's motion, whether private citizens or media, will have erroneous or incomplete understandings of the circumstances. Oh my God. Based on the above, it is proper and necessary that the state's March 22nd, 2024 motion for order be unsealed so that the publicly available record in this case more completely and accurately describes the relevant circumstances and events. Well, how does it fucking feel, man? Start turning over the discovery. How does it feel that you just have little bits and pieces? However, that the attachments remain sealed as to protect the identity of the named citizens who provided information in regard, because now they're confidential informants, in regard to the unsolicited telephone survey and to avoid any further violation. And so now they violated the non-dissemination order. No, they did not. You guys, this is absolutely fucking wild. And I'm here for it. I'm here for wild. You know why? because I will call it out. In fact, I'm going to start calling Latah County. I want 400 people better come forward. Who received these calls? Who received these calls? Crybabies. Whiny. Just, you have Brian Colbert by the nuts, okay? Hand over the discovery. Let the defense defend him, and you guys prosecute him and pick a jury that's non-biased or as well as one could be, you know? But again, this has been done in all these cases, and here we go. You know, somebody, oh God, I'm gonna go cry to the fucking night. Okay. So then here we go, which is, stop. We're gonna go ahead and look at the next big old filing here, which is that the defense is now objecting. Objection to defendant's motion to rescind order of the state's objection challenging the court. Let's see, this was filed on 3/29. The state objects to defendant's motion challenging this court's order prohibiting further contact with prospective jurors, which was entered after the state filed the motion and the defendant filed an objection. Defendants claim that this court failed to provide due process is belied by both the applicable law and the facts surrounding this court's order. Defendant's factual, I'm going to make this a little bit bigger. Defendant's factual recitation in support of his motion leaves much to be desired, leaving out critical facts that are fatal to his argument. Most glaring, defendant fails even to mention this court's revised amended non-dissemination order, which this court entered more than 6 months ago after briefing by the parties and oral argument. They most certainly talked about that. What in the actual hell are they talking about? I don't even have words right now. They said that we wrote the order. As relevant here, the non-dissemination order prohibits certain out-of-court statements, including out-of-court statements that relate to the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. On March 8th, 2024, more than 6 months after this court entered that non-dissemination order, the state received information from a Latah County resident who received an unsolicited telephone survey regarding this case. The state had little information about the call at that point and did not yet have reason to believe the defense had violated the non-dissemination order. By March 19th, however, the state had learned that multiple other Latah County residents had been called and learned the callers were disclosing information about evidence that would be presented at trial. What? Equipped with this new information, the state had serious concerns that the defense was violating the non-dissemination order and, giving the defense the benefit of the doubt, decided to contact defense counsel prior to raising the issues. See page 2 of the declaration. The defense confirmed that the calls were being made on their behalf, and the state expressed its concerns regarding the calls and informed the defense that the issue needed to be raised with the court. The state filed a motion seeking an order prohibiting further contact with the prospective jurors and asserted as the sole legal basis for its motion that the contact violated a non-dissemination order. Defendant filed an objection the same day that conceded the defense had conducted such a survey and indicated that a memorandum and support affidavit were forthcoming. The court then entered an order prohibiting either party from contacting prospective jurors. The order states the court had, quote unquote, reviewed the materials submitted by both parties and that a hearing on the issue will be held as soon as practicable. The court has now scheduled a hearing for April 4th, 2024, less than 2 weeks after entering the order prohibiting contact. This fuller explanation of the facts demonstrates that this court has provided defendant due process. Due process is satisfied when the defendant is provided with notice and an opportunity to be heard. Yet it is not a concept to be applied rigidly in every manner. Due process is a flexible concept calling for such procedural protections as are warranted by the particular situation. Dude, I love how they just pick and cherry pick through these through case law. I love it. What is this? Dude, I mean, I don't know. I think I get dumber every day when I hear them argue because I'm like, is this sixth grade? I think both sides, to be honest, are failing. I'm not gonna lie. It's one thing to have strategic, ways to defend your client and also strategic ways to prosecute somebody. But this is just, you're losing the plot, just like I feel like in Delphi, you're losing the plot, which is there was people murdered. There's victims. And this is, I mean, I don't know. This is why there wouldn't be a trial for a very long time right here. Like I said, this is I think this is horrible. I don't see why why them contacting prospective jurors to say, did you hear this? Yes or no. How that 1%, 400 people that were contacted would jeopardize your jury pool. It wouldn't, in my opinion. But you guys, this wasn't just about Latah County. They were doing this in multiple counties to then compare it to see if Latah County was overly biased compared to any other county in Idaho, which that tells you that they're trying to do their due diligence to show the burden of proof which lies with the defendant to show that he can't get a fair trial. Okay? And I think that's the more part of it. And this has been done in so many cases. And if Bill Thompson and the rest of his crew aren't aware of that, then that even just goes to show me that you're not like, when's the last time that Bill Thompson has prosecuted anybody for murder? Let me know. Write it in the comment section of this video. When is the last time that Bill Thompson, had a trial that lasted more than a week? Again, let me know in the comment section. But Ann Taylor has defended in criminal trials before, and so has Jay. So I don't know. But I'm curious of the timelines on things because I'm a big timeline person, and to say that that they were made aware on March 8th about it and that they didn't do anything about it, I think now I know what they may mean about that is because of that sealed document. That's how Ann Taylor, they were made aware of this on March 8th about it and they didn't do anything about it. How Ann Taylor and them are writing that report up is that you guys were the ones that told us based on your motion that you were made aware of it March 8th. Now, I want to go back and take a look at, you guys are going to make me go and check all this shit out. God bless America. hold on. All right, here we go. Comes now Brian Kohlberger, Brian through his attorney. So let's take a look. This is a telephone survey to explore the media stories the juror population has been exposed to is not a violation of this court's revised order issued. So the state has alleged the defense has violated this court's revised order. Specifically, the state alleges that the defense has violated the prohibition of discussing the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. Order, pages 1 and 2. The order also prohibits the disclosure of any information a lawyer knows or reasonably should know is likely to be inadmissible evidence in trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Order, page 2. The defense is aware of these prohibitions. After all, the defense wrote the original order upon which it's based. The state, however, misunderstands the prohibition in this respect. The defense is not disclosing information. The defense is asking prospective jurors in the county of Latah as to what information they are aware of that was previously disclosed vis-a-vis the press. Further, the revised order for non-dissemination allows for counsel to ask questions of the public to do its work. That is exactly what happened. Mr. Kohlberger is in his preparation for his change of venue hearing, is mindful of what the court must consider and the available means to obtain information for his evidentiary hearing. The state's motion and the court's order intrudes on one of the ways the defense will seek to establish prejudice pursuant to ICR 21A. Now, I want to see where they talk about these dates. All right, so here we go. I got the dates. On March 22nd, 2024, late on a Friday afternoon, the state filed its motion to prevent contact with potential jurors. The motion included attachments. The late afternoon Friday filing was a strategic action by the state. The state was well aware of the survey taking place long before its late filing on March 22nd. Reading the state's filing, it is clear the state was aware of the survey process by March. See? The state reached out to the defense counsel on March 19th. And so just like how they're trying to say that good old Nicky boy McLeland from Delphi was like investigating this leak of this contempt leak, Officer Payne was the one that was investigating these calls. So the state reached out to the defense counsel on March 19th, 2024, and scheduled a meeting for March 21st, 2024. By the time the parties met on March 21st, 2024, the state had at least one transcript of the survey and knew the questions that were asked. We need to start paying attention to what they're writing us. At no time during the 13 days between March 8th and March 21st did the state determine an emergency existed that must be brought to the court's attention. On March 21st, 2024, counsel for the state and defense met. The defense provided a curriculum CV for its expert and discussed the survey and its content. The defense informed the state surveys such as these were common practice. The state could have easily and likely did find that this very expert did similar survey work in Idaho on at least 2 other occasions. Surveys such as this or these meet the standard of care required of the defense in a capital case. Yet the state told the defense it wanted to tell the judge about this. The defense agreed to attend an on-the-record in-chambers meeting to discuss the defense work being done. The state chose not to wait. Counsel asked the state to refrain from giving the attachments to the court prior to a meeting where the defense could be heard because the court may take an action, thus prohibiting Mr. Kohlberger an opportunity to be heard. Unfortunately, through its letter writing to the court, the state has achieved previous action from the court without Mr. Kohlberger receiving due process. The state knew what it was doing when it filed a late afternoon motion with attachments. Mr. Kohlberger quickly filed an objection and stated further information would be coming. The court issued an order halting defense work without giving Mr. Kohlberger any opportunity to be heard. This is a violation of Mr. Kohlberger's constitutional rights pursuant to the 14th Amendment. So they're all playing ticky-tack, okay? And they are. But it's at what? It started because the prosecution had a problem with the defense doing its job. That's where the ticky-tack began. And what is interesting is that I was under the impression that they had a meeting and that they knew about what was going on from March 8th, from a March 8th meeting. When you go back and you actually read exactly what they write, there was no meeting. How they knew what was being done now from the motion that was now filed is that we would have known exactly how they would have known this, right? But they filed under seal, right? Where they could have just filed the attachments of these people under seal, which they do all the time. We don't ever get attachment A with all the here's what we're asking for. We don't ever see that shit. They know how to file that way. So that's bullshit. And then we would have known exactly. So how they knew about this was that, and I think Annie Potts made it perfectly clear when she said, they get this phone call and then they go running to the cops. They go running to the prosecutor to saying that I just received this phone call. They didn't go running to the defense and say that, hey, I want to make sure that the call that I just received was actually from your office. Did they? Did they call both? Did that person call the defense and make sure that, hey, I would like to talk to Ann Taylor because I just received this call? You know what I mean? If you're going to call and notify the prosecution, wouldn't you notify the defense to make sure that you weren't being like, well, how do I really know that you're part of the defense? Or who are you? You know what I mean? So that's something that I think is interesting, is that this person would be, if you're not biased, you would, or if you didn't feel comfortable, you would just not take the call. Well, here, somebody not only took the call, they recorded the call, which how would you know to record the call? How much of that call was actually recorded? Like, oh God, I'm going to start recording it. So was it like 5 minutes in the conversation, like 2 minutes into the conversation, 10? Who just has a recorder handy if you're just an average citizen sitting there watching Wheel of Fortune? Watching, I don't know, Jerry Springer reruns. I don't know. Just think about all that. That's just, but either way I look at this as just, I feel bad for the victims. I feel bad for the victims. I want to know what this master list is about. I want to know that when they say that the master list wasn't compromised. So there's already a master list as to who they are calling to be possible jurors. Like think about that. What's this master list? Go read the declaration of Brian Edelman when he's talking about that this master list of the jury pool wasn't touched. Like, what? So then you're asking people that it could never be? I don't know. I don't understand that. But all I think is funny is that you have Bill Thompson admitting now in a document that the things that the defense was saying and asking these people were factually incorrect. So just take that and smoke it right there. I'm going to go smoke it over here at Benihana's. Okay? Lana, your help is required now. What help is that? I don't know how I can help other than the fact that my ceilings, there's no more of a ceiling. I've beat everything with a bat looking for this chirping smoke detector. I think you guys think it's funny. You think I want to lay in bed and listen to that? Y'all are out of your fucking minds. I literally cannot find this. Okay. I thought I found it. It was gone. Next thing I know, I feel like somebody came in my home and put that motherfucker back up in this bitch. So I don't know what to say about it, but if you think I just sit around and love, like, yeah, chirp, chirp. Wild. No. Right? You know me, Annie. Come on now. I want to hear from Steve Gonsalves. You know, I want to hear from Christy. I want to just say, like, okay, what do you think about this? What do you think about these two, you know, what? This is a death penalty case. Everything changes because it's a death penalty case. That's what I realized. I realized when you want to look up stuff and how everything changes when you're going for the death penalty versus like we're just, you know, going to prosecute it not being a death penalty, there's so much that changes. And I think that until you read truly about that, you don't realize that. And so everybody wants this like, and it's just not like that. And then here, the littlest bit, you know, I read it myself and I'm like, holy shit, wow. Like I educated myself. I researched for hours yesterday about this because I really wanted to understand why Bill Thompson would have such a problem with this. And now I want to know who these damn citizens are that felt the need to call the police. You know? Now I'm going to have to go play bingo. Need to know now so I can save seats. I'm playing bingo tonight. You guys like bingo? I love bingo. Monday nights, I get to go play with all my 80-year-olds that are my favorite people in the world. Count me in for bingo, bango, bongo. Okay, I saved a seat for you. Thank you. Thank you. What's the special tonight? I hope it's you got filet mignon on the menu? Oh, bar bingo? Hell no, this is serious bingo, man. Did someone plant a device in your house? It now has a dead battery. Maybe that's why you can't find it. I'm telling you guys, I'm going to have to get in the ductwork in the house. I'm not bullshitting when I say, like, I cannot find this thing. I went through all of my son's toys. Like, it's not a toy. It's a total, it's wild. Everything's hardwired, too, so I've had to unplug everything. I don't know what else to do. The fire department thinks I'm nuts. 9 a.m., give Lana filet. 10 p.m., give Lana filet. Give me a goddamn steak. Lana, I wish you would accept my help. To get this bird out of here, come on over. Have at it. Get up in there. Anyways, it's not connected to a security system. Is Atlanta? No, I don't think so. I'll unplug my security system just in case. Anyways, you guys, this is all just wild. I need to print out all these documents. I am just overly stimulated because I can't even believe. I can't believe that they got Officer Payne on the job. Oh my God. We called Officer Payne to investigate. Stop. I thought I was like reading something that I'm sorry. That is kind of fucking, wow. Like, I'm like, this isn't real. So I don't even know, man. Let me just print away here. Let's get these docs all handled. Oh, here I go. Call Officer Payne. And I'm like, I haven't seen his name on a report, you guys, since it all happened. You know, there's been no. Oh boy. Page 4, 1, 5, 3. Okay. Oh boy. I'm just lost for words. Motion to unseal. Because the defense totally misrepresented what we said. We'll just give them the discovery. Declaration. Okay, here we go. I just... all over a fucking survey. Losing our dicks over a survey. That's how I feel. A survey that is normal. This is total normal. Can't believe Officer Payne's involved. We told Ms. Taylor that our office felt this information needed to be brought to the court's attention, and we proposed sending a letter to the court and attaching copies of the information received with copies to the defense. Ms. Taylor expressed concern regarding this procedure, indicating that she would want to respond to the information prior to the court ruling on the matter. Which would mean, like, you basically told Ms. Taylor you wanted ex parte communication. Sending a letter. Do you see when they say sending a letter? Ms. Taylor again expressed concern with our office providing the court with anything before an actual hearing. Not with anything. Put a motion in. Following our meeting with Ms. Taylor, we consulted with our attorney staff and decided to proceed with filing a motion with attachments. That motion was prepared and filed shortly before 2:30. So are we trying to say that there wasn't with a motion? What kind of motion? Okay, that's all my question is what kind of motion? All right. again. So there's 4 new drops. Again, I went over most of them up here. I just know that Officer Payne is back in business, and Officer Payne was involved in an investigation into who was calling Latah County residents. I'm probably going to be called wondering why I'm calling Latah County residents. Well, I wasn't. I was calling a friend of mine. And so, boo-hoo. They're going to ask me who I called to make sure that they're off the jury pool. I'm going to say I have no idea, or I'm not revealing my source. I have rights. Don't bother calling me. God, wow. Corporal Brett Payne is in documents, guys, for the first time. You guys saw it here first. Payne, back in biz, making moves, Payne. All right. A survey that certain people in true crime community are going to try and say was you. It was Lana. She started the survey. Yeah, man's a baddie. Man is a smarty baddie. (11:33 a.m.) Objection to defense motion. The state objects to defense motion challenging the court's order. That was on the 29th. 11:33 a.m. 11:33. How could these all be filed at 11:33 a.m.? That's interesting to me. I'm gonna have to check out their e-filing system. The state comes now the undersigned prosecuting attorney for Latah County. Comes now the state. The state objects to defense. Like, how were you able to file these all at 11:33? You uploaded them all at the same time and then just press send all at once? Interesting. I didn't know that was an option. So then what? So then we don't really have one that came first or second. So all of this, 11:33 a.m. on the 29th. Huh, okay. That's just when the clerk uploaded them to the system. I don't know. Electronically filed does not mean that that's when the clerk uploaded them. Electronically filed is actually when you go through the e-filing system. That's not true at all. See on the last page when it says electronically filed? Okay, there's like right now I can go and electronically file on one of my cases, and it timestamps you with a timestamp, which is exactly what you see here. It's not when electronically filed. That's not what that means. So, all right. It's starting to be drama. Enter Payne. What's the emergency, Payne? Well, someone called someone with facts. You guys go to that first one I read. But I think it's great when they're saying like there's questions there that aren't fact. Exactly. So let's point out the article that it came from because you guys just answered it. Right here. During the meeting, Ms. Jennings and I were told that the survey calls were being made on behalf of the defense. We expressed concerns to Ms. Taylor regarding that information. They know how to file the attachments under seal. This is all just a bunch of bullshit. All right, guys. Go back and rewind it, but it's all right there. Right here. We explained our concerns regarding contacting potential jurors and planting purported facts in the minds of those potential jurors who may not have heard those purported facts previously. This is particularly disconcerting because some of the facts referred to in the phone surveys are not true and consequently would create a false impression or understanding with those Latah County residents and potential jurors. And now this expert is going to take this and going to show where and why and how the 269 articles that he read is where he got that from. And if he cannot do that, then yeah, I would say that now you have a problem on your hands, defense. But if you can show that, no, this is where I got it from, this is the article, and I simply asked them if they had heard this before, and if they're saying yes, then I'm showing you guys that this is not fact, just like you said it's not fact. And they heard it before, and where'd they hear it from? Oh, from the pre-trial publicity within the three organizations that I told you guys about yesterday. Spokesman Review, which is connected with Idaho Statesman, the Pullman Daily, Moscow Daily, and then the Argonaut. So there's 269 articles from those three publications. That's where everything came from. So it's not the defense spreading the misinformation. It's the defense asking if y'all have heard this before. And some of the things were of fact, and then some of the stuff obviously is not a fact, but it's coming from these articles. And that's what people think is fact, or that's what you've heard before. So I'm just curious to see how the judge is going to feel about this. You know, this is a good feeler. So April 4th, there's a hearing on it. And let's hear what Judge has to say about this. And I want to know why Judge felt so compelled. He hasn't made, he doesn't do any compelled discovery, man. Gonna go out there and put an order that we can't do a fucking survey. Well, put an order out there, you know, compelling this discovery. Because guess what? That deadline that shit has to be to the defense by August or September. All these defense supplementals 1 through 15. Fuck having a whole compel this shit. There's a deadline now. So they just have to get this shit to you all by that date. And that's wild to me. That's it. But who needs all this time? You arrested this man in 2022 off of the evidence that you had, off of the discovery that you had. So where is it? What's going on here? Fuck it all. Ooh. All right, guys. You guys take care until next time.